But the due process you get in, say, if I were charged with murder, or let's say not murder, aggravated assault, right? So there's no death penalty issue here. I'm entitled, it's a felony charge. I'm entitled to a court-appointed lawyer. If I can't afford one, I'm entitled to all kinds of discovery. I'm entitled to a jury. I'm entitled to all kinds of stuff, rights of appeal, that I wouldn't be entitled to if I were in traffic court or if I were an illegal migrant in the U.S. subject to deportation. But if someone's charged with the death penalty, they not only get all the due process you get in a federal prosecution, they get more. They get due process plus. And that's something the prosecution has to keep in mind, because now it's an additional burden they've taken on in choosing to go for the death penalty. Is that right?
Yes. Well, in fact, the title of my third book is called Death Penalty Designs, Maximum Due Process. Right. And that is that when the state is seeking death as the penalty, the process that is due is the maximum process that can be due in our system of government. So so this is why I titled it Maximum Due Process. It's very, there's sort of a ratcheting up when you're a criminal defense lawyer or a criminal lawyer. There's you're a misdemeanor lawyer, and that's sort of the easy stuff, the fun stuff. That's, in fact, I say the best job in all of law is misdemeanor public defender. And then the next step up is felony, and that gets hard, and there's a big learning curve there, and then you get into it's very serious. It's not as fun. And then when you get to criminal, when you get to death penalty stuff, there's another huge thing. And a lot of lawyers that are really good at criminal law, it's like they're babes in the woods when they deal with death penalty, because you have to forget all the stuff that you think like hearsay rules. Hearsay rules, those are evidentiary rules that apply, but it's like in a death penalty context, it's different. Maybe something that wouldn't be admissible in a felony trial is admissible in a death penalty trial as a defense of life. And I talk about that in Death Penalty Designs. So, but I want to talk about behind the scenes from a public defender's viewpoint or a defense attorney's viewpoint about what they're dealing with now. And there's a lot of speculation I'm going to do here, and we can cover it from a lot of different angles. But once your client comes to you and says, okay, I did these things, and and then so now you have somebody who's admitted to you they've done it. All right, now you can say, well, we can fight it, and here's our possibilities, here's our trial, and we can make the state put to the proof, right? Or we can fight for life, and that's what to me that's what they did. Once they said, okay, he did it. We as public defender or defense attorneys, our win is life in prison without parole.
And just to take one step back to clarify for people, so not just a public defender's, a criminal defense attorney's job is not to defend just innocent people, right? It's kind of the nature of the business that most of your clients are guilty. So your job is not to defend innocent people. It's to defend people who may be guilty. They don't even know if they're guilty most of the time. I mean, they don't know the law either when it comes to that. But it's to compel the state to prove your client guilty beyond a reasonable doubt, to compel the state to the standard of proof that we as a society have imposed on it before it can lock a human being in a cage.
Right. Well, and that's very true. Now, the state had, I think, a very strong circumstantial plus the DNA. Okay. And the DNA to me is game, set, match. That, if he had not left that sheath next to the body with his DNA on it, it would have been over. Okay, he probably would have gotten away with it. In all honesty, that's the case. But the fact is,
you should mention too that when we say circumstantial evidence to the general public, because of TV and movie courtroom dramas, circumstantial evidence is, the cops are always complaining, right? We can't arrest them. All we have is circumstantial evidence. Circumstantial evidence is perfectly good evidence. It can be extremely compelling evidence. Plenty of people get convicted on circumstantial evidence, appropriately so, all the time. There's nothing inherently wrong or defective about circumstantial evidence.
Right. Well, but if you heard the state's proffer of what they had him traveling to this area with his cell phone like 20 or so times late at night, basically casing the area. And then you had him turning off his phone at like 2:00 a.m. in the morning, turning it back on about 4:15 during the murder incident. He's on the road at a very early hour in a very strange place. So you have opportunity. A car meeting his description is seen in the location. There's video of that. There's an eyewitness who saw a person in black that meet his physical description at the murder scene. There was an eyewitness within the house. Okay, all of that's very circumstantial evidence. And then you have, he bought the K-bar knife, which is a marine knife. He bought a K-bar knife in Pennsylvania with an Amazon gift card. The sheath that was found next to the body with his DNA on it was a K-bar sheath. Evidently, according to the state, and they said after the sheath came back with his DNA after this murder scene, he tried to cover up the purchase of the K-bar and tried to purchase a substitute, another sheath for a K-bar to replace the one that he had left. So you think about all the opportunity, all the circumstances that intersect, and then you put his DNA on the sheath next to the body at the crime scene with him no reason to be there. That's game, set, match. Now, why would that be problematic? Because the state may see there's two areas of problems I see. One is that there may be problems with the touch DNA and their confidence about how certain are they can defend that DNA. I know I've talked to Tiffany Roy, and there's some questions about reliability of touch DNA. Now, I don't know all the details of what exactly. Maybe it was blood, maybe it was skin. It would have been very good. But if it was just simple touch DNA, that might have been tougher. Okay. Now, and there might be crime scene contamination issues. You don't know. I'm just throwing out ideas. The second idea, though, is that how they matched up his DNA with the K-bar and with the DNA that was on the K-bar. Now, they said that what they did is they pulled a garbage bag from his father's house in Pennsylvania where he located, and they matched him through his father. But why did they pull that trash bag? It may have been that they got off a genetic database that's public use, and that might have been improper and might have been subject to suppression. So right. I'm just saying that, and the thing is that when there's a murderer on the run, the cops are going to do anything hell and high water to try to catch the killer, and then everything gets wiped out. It's like, we got to find him, and let's just, to hell with privacy and to hell with the databases and all that. We're going to find him, and we do, and we solve the crime, right? But now you're in a trial situation, and you're trying to convict somebody. Now we have a different situation. It's like, well, all that's forgiven. Well, maybe it's not. Maybe it is. Maybe it's not. I don't know, but there might be problems with that case enough to create. You could create legal issues that you don't want to create, right? And right. There's an incentive there to offer a plea deal.
If the gloves don't fit.
So I'm just throwing out some. So from a self-defense, so from a public defender or defense attorney, once you say, okay, my guy is guilty, then it's game over, and you got to go for the life in prison. And they could have been leveraging those problems within the state's case to say, why don't you offer life? We'll take life. And when they get life, that's a win. I mean, it's a strange, people don't understand because it's so extreme, right? It's so much on the edge. It's hard to make distinctions at that level, right? When you're talking about death penalty cases, death or life in prison without parole. That's a hard edge to be on. And to say, yay, we won, we got life in prison without parole, in most cases, that's a loss, right? That's terrible. Your client goes to prison for life. I mean, so you have to make distinctions that are hard to make at that edge. It's hard to explain it from I could give lots of examples and get really in the weeds, but I don't want to.
Well, I mean, as long as someone's alive, right? I mean, they're alive in prison. This guy for 4 consecutive life sentences, so forever. But he's alive. I mean, from one perspective, there's always possible redemption. Not that he gets released from prison, but redemption within prison. People change over time. It's always possible. When someone's executed, that's it. It's fait accompli. It is all over. Of course, some people would argue that there are things that some human beings do that warrants death, that there is no appropriate punishment other than death. My own personal concerns with the death penalty are mostly centered around how many times I see innocent people get convicted, how many times people get convicted when there is, to my mind, a reasonable doubt about their actual guilt. Juries are dangerous and unpredictable creatures. Irrational jury verdicts happen. Juries make mistakes, or we wouldn't need appellate courts. But also, the party doing the prosecution is the government. And the government sometimes acts in an unethical, inappropriate, oppressive, unfair, unjust manner. And they'll do that even when they're looking at having somebody executed. Not every time, but sometimes that can happen. And to the extent you don't trust the government, you don't trust those people, those bureaucrats, those hacks you wouldn't let them make decisions about what color car you would own. We're going to make them let decisions about who lives and who dies. I would ask people, how would you feel if the January 6th prosecutors could have put the January 6th protesters to death? I mean, they've considered them to be traitors, right?
Well, yeah, you're making points out of my book, and the way I approached my public policy book, Death Penalty Debates, the way I approached that is that it's a system. The question is not whether you and I agree that Kohberger should be put to death, all right? Because we don't have input on that. The public doesn't vote. What you're doing is you're empowering a system, and the system is a death penalty criminal justice system. It's part of the system. So you're empowering prosecutors and judges and juries to mete out death on behalf of the state. Now, as part of that, you have a collection of cases that are going to be subject to the death penalty. Within that system, there's going to be the people that maybe you and I would agree, oh, those are easy cases, but there's also going to be the close cases or maybe the actually innocent cases. We don't get to pick that. The prosecutors do, and those are human beings subject to frailties, as you talked about. And so it's a system, and you are empowering. So I think that you have to weigh the positives, the net positives, and the net negatives. And I laid out in the book that I've identified 10 net positives of the death penalty and 10 net negatives, and then embolden you as a reader to make your own choice, because everybody wants to advocate, well, this is what I think and you should believe me. Instead, I'm like, okay, I have some experience in this area. I'm going to lay out all the arguments that I've heard, the best arguments I've heard on both sides, and then let you make your own choice rather than just, okay, I'm going to tell you what I think. Because it's a very emotional thing. And you talked in the first part about the families, and I've addressed this in the book too, because there are outspoken family members who want the death penalty. Yes. There are also probably members of the family that don't want the death penalty. Okay, so if somebody's religiously opposed, and the problem is that can divide families at the time when they most need unification. So I think the death penalty system, people who are religiously opposed to it, it's like, well, you're going to, you want that person. Now all of a sudden your family's turned against you at the time when you've lost a loved one because you say the person should get life in prison without parole rather than death. I mean, I think that's a negative aspect of the death penalty, is it divides families. So you have some people speaking up and some people not, or maybe some people are against it. We had a case Rosemarie tried, in fact, and it's an example I use in the book, where it was a father that had killed an infant son and the state sought the death penalty. Every family member was against the death penalty, but the state still pursued the death penalty. They went through the trial, got a conviction. At the sentencing, the family, who was 100% against the death penalty, were all sitting on the defense side of the room, were prevented from telling the jury and the judge, telling the jury and the judge that they were opposed to that. The state shut them down and shut them up because they didn't want to hear it, because it's a state tool. The people that push it are generally state actors. And I thought that was very enlightening. Now, thankfully, that person got life because of great advocacy by Rosemarie. But don't think that the prosecutor, that's just like the people, everybody wants death. It's a divisive issue, and it's a political issue, and that's a problem. So, and of course,
a lot of prosecutors act like they get the psychological mindset like they're Batman. And I said this before, but I know prosecutors, if they were allowed to show up in court in a Batman costume, they would do it, complete with the utility belt and the cape and the mask and the whole bit. They feel like they're defending society against bad actors. And so no matter what they do, the ends justifies the means. And I always ask people to think about cases like George Zimmerman, like Kyle Rittenhouse, like Christopher Shore, the police officer in Minnesota or Wisconsin, the case I just recently covered. Now, in all those cases, those people were acquitted. And in my mind, appropriately so. In all those cases, I saw zero evidence inconsistent with lawful self-defense. But when those juries were deliberating, I had no confidence it was going to be a not guilty verdict. I had no idea what that jury was going to return. And the prosecutors, in at least, I would say in all those cases, were grotesquely overreaching in their efforts to secure guilty verdicts there. And they would do exactly the same thing if they were going for the death penalty in those cases.
Sure.
And the rest of us informed observers might say, but it doesn't even look like they're guilty. The prosecutor's going to work just as hard. Look at Nikolai Mew, the Apple River stabbing guy case up in Wisconsin. I still believe that that guy did nothing wrong, that he was acting in lawful self-defense. It's not even a close call. But because some of the community dynamics, the people he stabbed were high school students in that community. Everyone knew each other in that community. Virtually everyone in town has kids going to that high school. Nikolai Mew is a guy with an accent. He's an outsider. He doesn't have any children. He's not really enmeshed in the community. It made it easy for a jury to convict that guy on reasons other than the legal merit. And those are dynamics that come into play in jury trials.
The bad
can
behavior
lead to death.
The bad behavior we see from state prosecutors is countrywide. I didn't realize. I always, I was doing my little thing, and I thought, oh, our prosecutors are terrible and we got problems, but maybe it's just localized. But obviously, viewing these public streams, it's nationwide. I'd say 50% of the prosecutors that I've seen in public forums have been terrible. And I, this is what I found, is that the further up the chain that the prosecutors make it go, the worse it became. You would think that the death penalty, they'd take that really seriously and they'd be really careful. It's almost the opposite of that, which is frightening, because, it's like, well, there's no cost. Somebody's a misdemeanor and okay, you can let that get suppressed, right? No problem. It's a legal search. I'll drop the case. But death penalty, it's like, no, we're going to bring everything in. So it's exact opposite, which is terrible. And look at somebody like Solomon Anderson. Solomon Anderson, I think, was wrongfully convicted. I don't think there was evidence sufficient to prove beyond a reasonable doubt that he was guilty. He's life in prison now. He's exercising his appellate rights. But I mean, the system is really messed up. And there's, this is a human system. And that's a system I do not want to empower with the power of life and death over citizenry, because it's egomaniacs.
Right, egomaniacs. That's the point I was going to make. The entire system for prosecutors incentivizes them to secure convictions, not to secure justice, but to secure convictions. They basically have a report card of what their conviction rate is.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.